Another week and another set of legal considerations for us to think about. This week we're talking about contracts. And so we'll start off with a really high-level overview of what a contract is, how a contract is formed under Australian common law, and then we'll look at the ways in which businesses think about using contracts as a risk mitigation strategy in the context of AI, big data, and blockchain. So it's an important week. Some of you law students, you will be well on top of this, and so you might find yourself zooming very fast or skipping altogether the first lecture. It really is a high-level overview. We're not going to be delving into cases or anything like that at this stage. So think about it as a refresher for identifying what the particular elements are. If you're a business student, you might be thinking, I know what a contract is, right? But actually, I want you to stand back and actually take your time, if you haven't got any legal training, to think about contracts from the point of view of a lawyer. Because not all agreements are contracts as we understand that term under common law. And once we've finished this first lecture, we'll look in a little bit more detail at some of the legislation that impacts the way that contracts are made going forward. So there is some extensive material in Canvas. I strongly encourage you to work your way through it so that you understand what a contract is, when a contract is going to be enforceable. In other words, what are the ingredients or what are the indicia of an enforceable contract? And that'll help you understand the difference between a contract and other forms of agreement. So social agreements, for example, or agreements where there is no intention for the parties to be legally bound. It's also important to return to this idea that we keep skirting across over each of the weeks here, the difference between private and public laws. And I think in relation to contract, this is one of the ones where it's most important to understand the private law elements. If you and I enter into a contract in relation to a particular subject matter, say, for example, I decide that I am willing to part with this robot dog. I'm not, but just say I were, and we agreed in relation to the sale of this dog, then all of the elements of a contract would need to be there in order for it to be enforceable. Talk about what the elements are in a minute, but let's think actually, well, what's the end game here, enforceability? Enforceability means that if I don't, in fact, transfer this dog to you, if I don't do the things I need to do to make sure the dog is no longer in my possession but is in your possession without any encumbrance associated with that, then I have breached the contract. Doesn't mean that I've committed a crime. I haven't breached a public law as such, although if I somehow tricked you into believing there was a contract when there was none, then maybe I have committed a crime as well. That might be fraud, or it might be deception, or obtaining money by deceit, or something like that. But actually, let's say that's not what we're talking about here. We're talking about I'm just breaching the contract. I'm saying, no, I'm refusing to hand over this gorgeous robot dog. Essentially, that means I've broken the private law that you and I have agreed. And the consequences for that are that a court will enforce your order. Now, it might be a compensation order. I might need to compensate you. I might need to pay damages as a consequence of failure to deliver. Or you might seek an equitable order. An order of mandamus might be the most important thing here. In other words, an order that requires me to do the thing that I promised to do. Now, if I don't follow the order of a court, then yes, I have committed a crime, and they can send around the sheriff and a whole lot of extra consequences can occur. But for the most part, when we're talking about a contract and we're talking about enforceability, what we're really talking about is that there is a legal arrangement where both of the parties understand that as between the two of them, not between me and anybody else, I have an obligation to do something for you. In this case, transfer the dog into your sole possession without encumbrance, and you have an obligation to do something for me. In other words, pay the purchase price that we agreed, $1 million. So A contract, when I talk about a contract of common law, I'm talking about a legally binding agreement between two or more parties where there is intention to create a legal relationship and a set of binding obligations that occur as a consequence of the existence of the contract. So the contract itself is essentially our private law. It's a set of rules that you and I, the individual parties, mutually agree that we're going to comply with. So, which is different from a statute or a public law, which is a set of rules that the legislation or legislators impose on us and that all people who are subject to their jurisdiction need to comply with. The law relating to contracts and the rights and obligations of the parties to contract is made up of case law, the common law, but there is also legislation that impacts it. There's a tension between the common law's view of a contract as a self-imposed, freely assumed obligation. So we have this concept of caveat emptor, which is Latin for buyer beware. There is actually no prohibition against doing a bad deal. This robot, which by the way, I think when it was acquired, it was purchased at Kmart for under $20. If you and I have agreed that you're going to pay me $1 million for the robot, the fact that it's a bad deal doesn't invalidate the contract. I mean, that is a bad deal and you would be absolutely ridiculous to agree to it. But if all the elements of a contract are there, unless you're suffering some kind of incapacity and that I have tricked you in some way, the fact that it's a bad deal doesn't necessarily reduce at common law what the contract is. So this is where we see legislation coming in over the side. And in a subsequent video, I want to look particularly at the unfair contracts legislation and the overview, which we've spoken about in classes over and over again in different ways, of the Australian consumer law. So section 18 in particular, which prohibits misleading or deceptive conduct in relation to trade or commerce or consumers' goods in particular. So contracts that are entered into freely are almost always enforced by the courts. The principle of caveat emptor, so let the buyer beware, is deeply embedded in the legal principles that contracts should, for the most part, be upheld. So let's dig a little bit deeper into what it takes to have an enforceable agreement. Now, each of these elements, the law students in the class will probably be able to recite these in their sleep. When we're trying to work out whether a contract is enforceable or not, we need to be able to distinguish the contract from an informal agreement. So if you and I agree that I'm going to meet you after class for a cup of coffee and I don't show up, it is quite unlikely that you will be able to sue me for that. We have agreed, but the very nature of the agreement is an informal, friendly agreement. We can't sue our friends for not turning up to the pub on time. The more familiar our relationship is, so relationships or agreements between friends, between family members, the less likely it is that a court will believe that there was an intention to enter into a legal relationship. So thinking about that, businesses will often have wording in the documentation that records their agreement with their customers that makes it clear that the intention is that it is a legally binding arrangement. And so intention is the first of the elements on this slide. It's going to be hard to look at in a video, but I'm sure you're following along at home. And essentially, it requires that the parties demonstrate that they intend to create a legal relationship. Now, what's interesting here is that the courts take the view that when the nature of the relationship has something to do with business or some sort of commerce, the presumption will be that they intended for the relationship to be a commercial one. Now, let me use the example that I started with. I promised to meet you after class and have a cup of coffee with you. Now, because we have a commercial relationship, I am your teacher. And so me making that promise, it sits in a commercial context. So the starting point may well be that we're presumed to have a commercial arrangement in place. And so let's forget all the other elements for now, but that I made a promise, therefore it should be enforceable. So the presumption will start with that it's a commercial relationship and it should be enforceable. So the onus will be on the party who wants to demonstrate that it wasn't intended to be a legal relationship to demonstrate that. And so in that case, if you were suing me for not showing up for my cup of coffee with you, my defense would be, it's not a commercial relationship. There was no intention for it to be a binding contract. And I would demonstrate that by saying, well, we have the times under the contract when we're supposed to work together. I'm supposed to deliver an hour of content online. We go to the toots. We do whatever the other things are. And this was outside of the confines of that. So there was no intention that it was a binding or additional arrangement. Similarly, if you make an arrangement with your friends or your family member and they don't show up, they don't do what they said they would do. So let's say you agree with your brother that you're going to buy their car and you agree a price, you agree a time for the handover, you show up with the cash, you're all ready to go and your brother's sold it to somebody else. Now, actually, it's rare for people to sue their brothers, but it does happen. You would be suing for them to hand over the car or for the damages because it's going to cost you more to get the same car somewhere else. And your brother might be saying, it was never intended to be a legal relationship. It was never intended to be binding. And the onus would then be on you because the nature of it is a family relationship. The assumption will be it wasn't intended to be binding, but the onus would be then on you to demonstrate that actually it was. You negotiated a price. It was very clear that it was more or less than whatever the market price was. You were paying the amount of money. Everybody had agreed that it was going to be a legal relationship. Again, more materials on Canvas in relation to this. I don't want you to overthink it, but it's important to be aware of this requirement. Now, the other thing we need for an agreement or a contract to be enforceable is we need there to be an agreement. In other words, the parties need to agree something. Now, in the most old-fashioned way of thinking about this, generally it comes across as somebody makes an offer, and that offer is accepted without any variation or change. So an agreement will be formed when one party makes an offer and the other party accepts it. The offer needs to be clear, definite, and intended to be binding when it's accepted. Now, that's something I'll talk about in a little bit more detail when we get down the list into certainty. But what's important here is that there needs to be a meeting of the minds. Now, the old-fashioned way is to look for an offer that has been accepted without any variation, so an unqualified agreement to the terms of the offer. But there are cases that demonstrate you don't necessarily have to have that clear offer and then acceptance. It may well be that the agreement can be identified, provided that there's sufficient certainty, out of the actions and the meeting of the minds of all of the parties. One of the things that might interest you as business people is the way that the law has evolved because of this requirement for a clear agreement, that often businesses structure the way that they I'll say the term loosely, offer their goods and services, is in fact so that their customers make offers to buy goods and services from them at the price that is on the label or on the price tag, etc. So, and when you think about this makes sense. If you go into a shop and you pick something up, if you were obliged to buy it at that point because you're picking up the goods, demonstrated acceptance of the offer, well, that would be unworkable and just untenable for you. Similarly, people in shops need the opportunity to say, no, I'm not prepared to sell that thing to you because you're too young to drink or too young to smoke. That might be another law. Or like quite simply, and I think there should be more of it, that colour just looks terrible on you. You shouldn't be allowed to buy that. But no, seriously, for whatever reason it is, particularly in relation to a contract that's going to go over a period of time, if a vendor is concerned that, in fact, the person may not have the capacity to pay the price over time, they should be in a position where they can say, no, I don't want to do this deal with you. I don't agree to sell these things to you. Now, of course, they'll have a binding contract if they do accept, and that means they could sue for payment. But who wants to sue for payment if you don't need to? It would be much cheaper and easier to sell the goods to somebody else who can pay, which is commercially what most people want to do. Our list is consideration. A consideration just tends to sound a lot more tricky than it really is. What the requirement for consideration means is that each party needs to have a right to get something, and each party needs to have an obligation to do something. So going back to the sale of this robot dog, no actual contracts will be made as a consequence of the making of this video. This dog, if I'm selling it to you, the consideration that I would be taking on is the promise to hand this dog over to you without any instructions and with full working batteries, whatever the promises I make are, in exchange from your promise to pay me the cash. And so once we've exchanged promises, the consideration is technically the promises, and then the actual execution of the contract, the fulfillment of our contract obligations is I have to meet my obligation to transfer the dog to you. You have to meet your obligations to give me the cash. And again, consideration, we'll talk about privity in a minute, but again, it's a private law. So consideration needs to move between the parties, or at least on behalf of the parties. So what else do I want to say about that? The other thing that is really important here is remember that the courts will enforce a deal when it is a contract when it is a valid and enforceable contract. It doesn't make any inquiry into whether it is a good deal for somebody or not. Now, there is other legislation which will look at unfair contracts, and there are crimes in relation to fraud and deceit, etc. Put those to one side. But from the point of view of contract law, it doesn't matter whether you're spending too much or too little. The court doesn't care. The court just cares that we have the intention to enter into a legal relationship. We have reached agreement in relation to the subject matter. We have certainty, something I'll talk about in just a minute, and that there is consideration. Now, if the consideration doesn't need to be of equal value, it just needs to be something that is valuable and that is going to happen in the future, not in the past. So there are some very limited circumstances where a contract may not be valid because the price is unfair, but that's a legislation overview. In a common law sense, the question is there consideration? Do both parties have an obligation to do something and a right to receive something? And what they might need to do could be to deliver the goods, it could be to pay money, it could be to keep some kind of promise, and the rights that they get could be to receive the money, receive the goods or services, or some other kind of benefit that has been promised. The next one, and the last from the point of view of what makes a contract enforceable, is the question of certainty. So the terms of the contract need to be certain or capable of being made certain. This means that the essential terms of the contract need to be agreed upon, or at least capable of being determined in a way that the parties have agreed. So once again, go back to my robot dog example. If we have agreed that I'm going to sell the dog to you, in exchange for your promise to pay me 20% of your salary for the next year, I don't know exactly what that is at the time. And I just said salary, but let's say you're a casual worker and it's 20% of your earnings for the next year. I don't know what that 20% is going to be. It might be a large number, it might be a small number. It doesn't matter that I don't know the exact number. What matters is that there is a clear and certain formula for working that out. So we don't necessarily have to have the detail, but we need to know, we have to have a certain way of doing it. The last point I want to make before I will move on to the next video, where I'll start to look at some of the more broader concepts of contract law, including privity, is I just want to point out, did you notice that there was nothing in this list of fundamental requirements for a contract to be enforceable that requires the contract to be in writing. A contract can be formed without a document, without a signature. They can be contracts can be made verbally or orally. They can even be made by conduct. Complete silence is usually not acceptable, but acting in a way that demonstrates acceptance of the contract terms may well be. Now, there are some kinds of contracts as a consequence of laws that go back to the 17th century, referred to as the Statute of Frauds, that mean that certain types of contract disputes will not be heard by a court unless there is written evidence of the contract. So we call this the parole evidence rule. Again, it's an example of the use of terminology that just the concept is so simple that if we said it in plain English, people wouldn't pay us the big bucks. Parole evidence is just a fancy term for verbal evidence. So the parole evidence rule says that certain type of contracts, in particular contracts that relate to land, but there are other types as well. But just think about land for the moment. The court can't hear any verbal evidence that is contrary to or different from the written document. And in relation to land, that's the general rule, That is the general rule. If we have a written document, it takes precedence over evidence about our verbal arrangements. But in relation to land and other things covered by the Statute of Frauds and similar legislation, so the Australian consumer law is a really good example of this, unless there is something in writing, the courts cannot hear that dispute. So this is something we'll talk about in the tutorial, no doubt. But it's important. There are two things to recognise here. Firstly, there is no requirement for writing in order to have a contract. So do not think just because there's nothing in writing, you don't have a contractual obligation. You may well do if we have intention, agreement, consideration, and certainty in place. But if that contract relates to something that is the subject matter of law that says it needs to be in writing, so the transfer of an interest in land, a lease, for example, but even under the Australian consumer law, things like something that was sold under a door-to-door sales campaign, credit contracts are a good example. There are a range of different types of contracts where consumers are quite vulnerable, and so writing is required. It doesn't impact the contract itself. It just means that a court can't hear the dispute. So it's not a crime to accept money under a contract that hasn't been in writing, but you can't actually enforce a dispute in relation to that arrangement without a document. Deep breath. Questions, concerns, frustrations, compliments, any questions you have, please do not hesitate to contact me. And in the next video, I'll start to talk about some of the other concepts, and as we move into thinking about how contract law works in the context of big data, AI, and blockchain in particular. Cheers.